is Rhonda Finney, and I'm here as both a parent who has been harmed by a well-known psychologist's unethical behaviors, and as a professional who's trained in a field of behavioral science, studying people, behaviors, culture, processes, and systems. I've submitted complaints in the past, one of which you found the psychologist, who was my son's child psychologist, to be in violation of administrative codes, and he entered an agreed order with Texas State Board of Examiners of Psychologists. Both he and the above-mentioned well-known psychologists were involved in my family law case, consulting one another and influencing one another. I think today you're going to hear primarily from lawyers and those who are benefiting from an adversarial process and competitive approach. My family has been adversely affected by family law and by a psychologist. My ex and I have been able to resume 50-50 joint managing conservatorship custody outside of court and without the interference of an attorney who's driving the litigation. But the damages that have been done are irreparable. I'm shaking because of what I've experienced. We are both financially exhausted. I've faced homelessness for a few years. My ex, who's a family physician, is facing bankruptcy. He has been unemployed for a year and a half due to the outcome of our family law litigation. My son is angry, my 15-year-old son, that I have to nurture and develop to be a young man, has been adversely affected by all this. And I'm fearful of what you're going to hear today and what you're not considering this. His childhood was pretty much taken from him at the age of 10 due to our family law litigation. I assessed the problems to be a lack of validity of the evaluations with no well-established baseline. It's a subjective manuscript in which people's biases, assumptions, and inferences are prevalent. The way the evaluations are used in family court are as instrumental tools to lead to the following phenomena. Parental alienation, either by making child custody contingent upon the release of a completed report, for which many psychologists will demand more money, or once a report has been released and traits and/or disorders have been declared, making the targeted parent appear less fit than the other. Misdiagnosing, whether accurate or not, and I'm diagnosing, whether accurate or not, the parents get profiled. You're going to hear a lot of profiling today, angry, unhappy with the results. Confirmation bias, just for the mere fact that a parent is targeted to be seen a certain way, there's an element of confirmation bias. Gaslighting, a power and control dynamic which gives one parent power and control over the other parent and the children. Marginalization, dehumanization, in which they're traumatized, yet they're not allowed to show emotions. They're reacting abnormally, or they're reacting normally to an abnormal situation, yet for some reason people forget about the complex trauma that they're experiencing. Exploitation and extortion. It's very expensive to navigate a family law litigation. Even the psychologists that they're paying actually become part of the problem because they don't have the financial means to afford them. The lack of accountability for inaccuracy and error and oversight, and the contributions or weight a psychological evaluation has in family court, especially when there are systemic problems in family law. Family law is broken. I think that if you were to get an attorney outside of their paradigm and talk to them, they would all agree family law is broken and it needs to be revamped. Right now, it is devastating families who are in crises. They go through this process because they need help, they need intervention, yet what's happening is they're being taken advantage of. They're being further polarized, and they're being exploited through these psychological evaluations and extorted. So please take these things into consideration. Without taking more time, I provided you information on the back side. You'll see some of the solutions I've offered. I'm an organization development practitioner. I study systems. I study human behaviors. It's very similar to industrial organization, which is in your field. Thank you.
First, the timer, and then return. This one. Good morning. My name is Christy Taylor. I'm a mother of 3 children, and my oldest was born with severe heart defects and autism. She has gone through 20-something surgeries to extend her life, but she was so traumatized by the age of 5 that she no longer wanted to live. But with the help of 1 or 2 very gifted psychologists, she's now 19, living independently, engaged to be married, and wants to live. So you could say I'm a big fan of good psychologists. But psychologists are people too, and sometimes they lose their way. 2 years ago, I encountered a psychologist who's in this room who lost her way. She violated board rules and devastated our family. Even as a person, I'm an attorney with education, resources, and tenacity. I found it very difficult to file a complaint against this psychologist. She's a former board member, Dr. Alissa. It has haunted me that I haven't spoken up. It's been years. I am shaken also. I'm a former advocate for children involved with CPS, and now I work to educate judges about mental health. If I don't feel safe speaking up, then who does? In my case and in many others, it appears the financial gain of writing reports like this for $20,000, $30,000, $100,000 is just too tempting. An out-of-town psychologist reviewed Dr. Sherry report and found obvious bias. She cited selective reliance in reporting, much of the things you've heard today, omission of relevant clinical information, puzzling recommendations, were her words, with questionable relevance. To me, after meeting with other families, it appears Dr. Sherry picks a winner and then writes an opinion around that winner. And the winner often is the person who's paying or the person who hires the attorney with whom she has the best relationship. And there's significant barriers to filing a complaint after it's all over. Dr. Sherry requires, even though she has spent time on this board, up front that you sign something waiving your right to complain about her. I don't think that's valid. I haven't tried to challenge it yet, but I don't think that's legal. I've exhausted all of my resources. I had to sell my home, move my kids to a rental home, borrowed from every family member I know to finance an attorney that she would respect and back down. I can't afford to go back to court to challenge this unethical behavior. But to combat this type of abuse, I urge this board to create an ombudsman. I don't know what your budget is. I don't know if that's possible. But to also strive for greater transparency. I applaud you that your website made the rules accessible and had some transparency, but there was no announcement of this meeting. And in fact, the only way I found out is that Dr. Sherry had sent a note to her colleagues urging to come tell you about how all the crazy people are coming to complain and harass her. And so someone forwarded me that email. She spoke for you. She spoke for the board in this email and said, the board is beginning to recognize the problems of frivolous complaints and is sensitive to possible unmet mental health needs of children and families. Well, I'm here today as one of those people Dr. Sherry would call frivolous. And the mental health needs of my children went unmet for years because Dr. Sherry opined that even though 7 other doctors had diagnosed my child with OCD for many years and treated him, she opined that my child did not have OCD, but that my parent alienation had given him OCD-like symptoms. Dr. Sherry never met this child. This wasn't a custody evaluation. This was just a psych eval of me and my ex-husband. When questioned about this in court, my child's treating psychologist, Dr. Kevin Stark of UT, stated that Dr. Sherry's opinion about this was psychobabble. Unfortunately, wealthy people can purchase psychobabble, and it's working. For a living, I help courts try to see through problems and systems improvement. And so you can imagine how frustrating that would be to be someone who is fixing problems in courts for a living and then suffering through this in silence. Courts have no way of knowing about these abuses. I couldn't tell the judge. I couldn't tell anyone. My lawyer warned me that if Dr. Sherry was angry with me, that it would negatively affect my case. And the family law community, as you've heard, is very tight-knit. They depend on each other for their next case. So even colleagues who said she's completely lost her way, she's for the highest bidder now, have said, don't say I said that. I'm going to have my next case with her on the other side. So So even these witnesses refuse to speak up to save their own livelihood. When desperate parents give her bad reviews on Yelp to warn other families, she replied on the internet that these pages and pages of terrible reviews should be ignored because they're written by disgruntled former clients with mental illness. Recently, several families who have been nearly destroyed by psychologists like this have found each other. We've agreed to file complaints in numbers, hoping that they wouldn't be dismissed then. Dr. Sherry is aware of this, and it may explain the next part of her email that she sent to all of her colleagues before this meeting. She said social media has created a way for these individuals to congregate, to contribute, and to encourage each other's narrative in a way that is destructive to our system. Well, I'm one of those individuals. Dr. Sherry would have you lump me in a category of crazy people, even though I've never had a diagnosis, and Dr. Sherry didn't diagnose me either. And she would have you dismiss our complaints. In my case, the court saw through the puffery of the report, ordered my ex to help pay for his daughter's adult disabled support, and made me the decision maker of our mental health, of my children's mental health. But I don't think it should have cost me a year's salary and the sacrifice of my home and countless days of toxic stress to combat an ethical board. I understand this board's concern about the need for efficiency and safety. I have the same concerns. But I would like you to exercise extreme caution when you're thinking of adopting policies that psychologists can use to silence people like me. People that you need to hear from, to hear where the system is broken, because that's your mission. After today, I am going to file a complaint, and I hope that my voice will help you to do your job to protect the public.
Cheryl Bracker.
I was in the hardest place to get there. Hi, good morning. Happy Valentine's. My name is Cheryl Draker. I have a master's in psychology for 22 years. I've been a practicing lawyer for 32 years. For the last 20 years, I've had the opportunity to practice in the family law arena in these child custody cases. It has shaken me to my core, what I have witnessed. It has become my personal mission to contribute what I can to get this system headed in a different direction. I have met, excuse me, with former judges to talk about what I've seen, what they saw when they were on the bench, and how the train came off the track. I have met with legislators and have meetings set up to discuss what is happening in this arena. It is detrimental to the kids. This is supposed to be about the children. It is not. It has kept me up at night. It has made me physically sick to see that our system of justice is being handled in this way. I have 3 points I would like to address. One, the dual relationships. Psychologists, custody evaluators are functioning in dual relationship. The court appoints a neutral psychologist for a custody evaluation. After the evaluation is complete, the psychologist then moves to an advocacy role. They receive additional money to perform as an expert witness in the courtroom. They, during court, huddle and meet with the chosen party and their legal team as any retained expert witness would. In the courtroom, when presented with evidence that was never made available to them during their evaluation, let's say a new witness, they refuse to take this in as a judge would, as any neutral would. Oh, I didn't know that when I wrote the report. Let me take this into consideration and see how this impacts, if at all, but let me take it in. There is a refusal to do that. It's a denial. It is a digging in of defending a position, which is not the role of a custody evaluator. Mm-hmm. It is the role of a paid expert witness. These two roles have morphed. It is wrong. It is no wonder to me. I've never been in a custody fight. It is no wonder to me that all these people are lined up to talk about this. The sense of betrayal that they feel from this dual relationship, I can't even begin to tell you the pain I've seen. It's wrong. As a lawyer, if we act in dual relationships, we are disbarred. And there's a good reason for that. Total breach of trust. I cannot imagine that there is not a rule within the psychology world that prohibits this. How could anyone who's been in the system not find that objectionable? How could they not feel that the system had failed them, that the court-appointed psychologist had failed them? My second point, flawed work product. Again, my observation has been that the child evaluators fail to remember what their job is. Instead, what I have read are reports that act as the finder of fact. That's not their job. Their job is to report what they have learned. It is the judge or the jury's job to decide in a he said, she said, whose truth are you going to believe? If this turns out, this is what this party said. If that turns out to be the fact, then I would recommend custody in this fashion. Instead, they don't adopt that role. They again act as an advocate, picking a side in very black and white terms, which concerns me greatly, the polarization. And everything that is ascribed to one party is painted as truth. You can take everything I have seen in a report that this party says as truth. There is no barometer that we as psychologists have that says this person is, their veracity is better than this person. There's no test to administer. Nobody's giving lie detector tests here. That is not the role. The role is this party's perspective, this is this party's perspective. Should the judge or jury believe this, then custody should follow in this fashion. I'm sorry, this is my volunteer pro bono mission now to write this system. It is so destructive. Most disturbing of all, I have seen selective use of psychological reports in history. I have observed psychologists' written work product to ignore negative scoring, ignore prior psychiatric diagnoses, ignore all poor indicators about one party, ignore diagnoses, historical diagnoses, histories of people being in treatment for mental disorders, not even mentioned. Only cherry picking the selective facts about the party they want to endorse for custody. In the same report, they'll talk about the other party in a very black and white fashion, not mentioning all the good qualities that a party has, only cherry picking the worst facts that they can find. Facts that aren't even substantiated. Very disturbing.
Was that you about on your third point?
I am. Fees. I'm on my last point. What starts as an understanding that the parties will be spending $10,000 to $15,000 for a custody evaluation morphs into an $85,000, $150,000, even $250,000. $250,000 for a custody evaluation is insane and asinine and outrageous. One would think that with such steep charges that the psychologist was investing a great deal of time with the parent and the child. Such is not the case. In a recent custody evaluation, there was, in the time, less than 2 hours spent with 2 children. What was the bill? $84,000. This system is broken. I'm sorry to say it has been corrected. I believe the judge needs to retake custody evaluation over because, frankly, we psychologists are doing a horrific disservice to the families of Texas. Thank you.
David Naylor. Speaking on behalf of the organization, I believe.
Yes, I'm a founder CEO of Omega Healthcare. We treat mental health and addiction. Reading statements from two parties who are not able to be here today. They're out of town.
As you get into this, let me state, due to the number of speakers that we have, I'm going to adhere a little closer to 3 minutes. So
3 minutes total? Okay. I'll read fast. My name is Lauren Walker. I'm a parent whose life was devastated by an unethical custody evaluator. I have a beautiful 6-year-old daughter, and we haven't seen each other since July 2018 when a jury terminated my parental rights. I went from my daughter's primary caregiver to being removed from her life altogether in less than 2 years. My family spent over $1 million defending me in the custody battle, 17 hearings in all, that was fueled by the custody evaluator's continual recommendations to the judge. I was beaten badly by my ex-husband, which I've seen the evidence and videos of that. I experienced a traumatic brain injury from him kicking me in the head with his boot. My daughter and I at one point received a protective order to keep us safe from my ex-husband. When I left him, he continued to use the court system to abuse me. The termination petition was instigated by my ex-husband, not the state, and the idea to terminate my rights originated from the custody evaluator who grossly exceeded her scope and violated the rules as well as the code of ethics. Not once did any other professional recommend that it was in my daughter's best interest for my rights to be terminated, yet that's what happened due to the custodial evaluator's actions. Dr. Jonathan Gould, who is a renowned forensic psychologist, reviewed by Dr. Alissa Sherry's evaluation reports. I have a 27-page report with details of his findings. He concluded that her report was completely flawed and did not qualify as a custodial evaluation. Dr. Gould cited concerns about the information included and excluded from the report, for example, the inclusion of speculation and hearsay opinions and the exclusion of direct observation of parenting, failure to assess critical parenting attributes, which was the purpose of the evaluation, misuse of psychological tests, use of unreliable methods and lack of scientific-based findings, and notable differences in the treatment of the parents. Dr. Gould recommended that the jury should not use the evaluation as evidence to support its decision. My daughter's and my story is terrifying and heartbreaking. In closing, I plead with this board to conduct strenuous oversight and investigation of its forensic psychologists involved in family court cases to prevent this tragedy from happening again and to correct cases that have already ended in tragedies. Thank you, Lauren Walker. There's an expert opinion here from Dr. Jonathan Gould. I don't know if I should read that or then the next statement.
You made your point.
Yeah, there's one more statement. Should I?
Okay.
And this is a short one. Our names are John and Gay Walker. We reside in Arizona and are unable to attend in person. Our family has been irreparably harmed by the seriously flawed custodial evaluation conducted by Dr. Sherry and her unethical behavior. Our daughter's parental rights were terminated after a 2-week jury trial. The judge refused to terminate rights after the evaluator requested a court order to recommend termination. The judge voiced her concerns about our granddaughters having abandonment issues. The evaluator's testimony at the trial was extremely damaging. As a result of the termination, we have lost all contact with our 6-year-old granddaughter, even after multiple requests. Up until the termination, we were in constant contact with her, and she was well aware of her Arizona family. We have been erased from her life. We were never allowed to tell her goodbye or do not have any idea of what she's been told. I'm not sure how any evaluator believes that this is the best interest for the child. The problems I are seeing extremely costly, lengthy, drawn-out custody evaluations spanning over 2 years from July 16 to August 2018. The evaluator's initial contract estimated the cost to be $20,000. The total cost at the end of the litigation and jury trial was $230,000. Solution: place time restraints on evaluations enforced court order timeline. Place a cap on the amount of evaluator is allowed to charge. Point number 2, my husband and I were never taken seriously as interveners, as co-conservators with our daughter. The evaluator never followed through on a home visit that we offered at our intended place of residence in Austin, nor was my husband ever observed with our granddaughter in any capacity. The evaluator never spoke to any members of our family and did not ask for collateral witnesses. Solution: request evaluators equally consider all interveners as possible placement of the child. And the last point, the evaluator's report was extremely biased. contained hearsay, multiple errors, contradictions, assumptions, and running together of stories. A letter submitted correcting errors to evaluator via our attorney was never acknowledged or corrected on the record. Solution: request the ability to read individual interviews and make any corrections prior to the final report being submitted. Request all communication between evaluator attorneys, including ad litem, and all parties via email and made available to all parties involved. Any telephone conversation should be recorded, no ex parte. I think it would be negligent of the board to dismiss complaints against psychologists who are involved in family court cases that have lasting and devastating consequences to children's parents, grandparents. More oversight, restraint, and direction must be provided. And I'll finally say, I know the party pretty well. I've never seen this kind of, I don't know y'all's field, but there's some major corruption going on. Just as an outsider observer, I'm really surprised at what happened in that case. She's a good person and a good mom. That never should have happened to her. And the really everlasting effects are going to be to the child. So, thank you.
Thank you. Michelle, you know